Your Honor, item number 21, 22, 22 today was fixed for hearing, but Your Honor, due to some urgent calling for medical urgency in my home. So after 4 weeks, maybe please. Respondent.
I'm for the,
I, I have taken consent.
22, item number 20.
21.
21.
Yeah.
22. Yes. No.
21 is I have taken the consent. The council is yes, Your Honor. Yes, Your Honor. Yes.
With the consent of others are here, on behalf of Y Minute, I beg to make sure item number 13 minute. Matter is posted on 27. 13. Yes, madam.
Yes, Your Honor, is available. Your Honor, on 27, I have some difficulties.
The leading counsel has given consent, my lord. Leading counsel for the respondents have given consent, my lord. Mr. B.C. Pathak, my lord. Mr. B.C. Pathak has given consent, my lord, on 27.
Yeah, I'm also responding. All the respondents.
B.C. Pathak, Mr. B.C.
B. Pathak is a leading counsel.
He's a leading counsel.
I don't know, like, you know, see, for 27, we have already cleared like some matter out there.
You both go outside and come back. You say you have consent. He said he
Actually, leading counsel has given the consent.
Any objection on 27?
Yes, sir.
Yes. So,
Then
then you begin.
13 minutes. Then 13 minutes.
The first week of June, the Lord's. First week.
Actually, my lord, plan ANC will appear in this case.
Oh, Mr. Counsel, if you are not aware of the he is opposite, how can I do it? You go outside, take a consent whether on that day it can be taken up or not. That's all. Yes, Minister. Come back. Take a consent, go to you.
Lordship, I want to beg to mention item number 12. His main counsel is out of station, and I have already taken consent from other party, and it may be released after 2 weeks. Yes. Okay.
Madam, I have one judgment from Apex Court. Madam, can we please paragraph 14 and 15? 14 and 15. But here the decree was determined. It's page number 40. Page 40.
I will do this. Well, I'm getting my point. Last thing is I'm trying to convince you. You are being convinced. You have regarded evidence.
Yes, ma'am.
Against the advice. Before whom? Before the artist civilians meeting.
Yes, ma'am. Yes.
Now, where is the provision of the limitation? And how section 5 will be applied?
Madam, there is no specific limitation here.
If there is
However, my lord, in the section 9 of AFR amendment,
But
it says the 30 days
30 days from,
passing of the order, passing of the decision. My lord.
30 days from passing of the decision. So therefore, when is this? Now therefore, we would like to know your application file before the Nagaland district.
Yes, civil judge.
Where is that?
My lord, miscase application is at page number 34.
I If you under section 9. Isn't it? Limitation cannot be made applicable when there is no specific restriction. Okay? Your all right, if you on the basis of the its frontier regulation, isn't it?
Yes.
Right of actually is under frontier regulation.
Yes. Yes. Yes, section 9. my lord. Yes. Yes, my lord. Any party aggrieved by the decisions of the village authority may appeal within 30 days before the inter-village territorial. Yes.
Any party, any condition of village authority, before the inter-village related customary code or address customary code by whatever number, you want to receive the services that is good of the case.
Yes.
Even if this is not the address customary code.
Yes, madam. But for appeal before the civil just civil just
To provide you three.
yes, madam.
So where is the limitation?
There is madam no specific limitation.
There is no limitation. So, this question is answered, that when there is no limitation of limitation, you have committed a mistake by filing an application under 65.
Yes.
This is one step. Second, suppose it is an appellate authority. You have filed an application and it has rejected it. Now, what will be the course of action? So therefore, you go to this judgment. That's why I was asking you for last 3 days, if you can find out, and you have taken a definition of degree. Isn't it?
Yes.
You take this decision, 2023, 1 CLR 188. Very important judgment for you all.
Madam, please.
You need repeat it.
Yes, sir.
2023 1 CLR case 188. Tarong Yapi versus Taken and Senator. Being a local partner.
Yes, ma'am.
And I had to do hardcore research to find out about it. And I see an order 2021, 2025. In civil and enumerated case number 01, and in this case number 01. In the case of the convocation of delay under section 5 of the limitation of preparing the against Kerba received 11/11/2023 and 14/12/2023. The learned board below. Dismiss that proceed the same after
Matlab, there is a interim period.
Of the maintainability of or because generally a question may come, this order is available. If available order, written revision in time. As long as they are object of the clarification of
Item number 2, may I please your lordship?
Filed under section 528 of the BNSS 2023, seeking quashment of Papu Hills PS case number 22/2025 under section 406/417/420 IPC. First of this court is of the considered opinion that for further determination, the case diary of Papu Hills PS case number 22/2025 shall be required to be perused. Accordingly, reach this matter.
Lordship,
Yes,
if your lordship is pleased, lordship, we may seek to file an additional affidavit. Lordship, a few documents are missing in the said petition.
you file it, we'll say the case diary, give a date.
Okay.
Papu Hills, scan copies of the case diary.
Next week.
Next week,
Yes.
give a date.
So, Lordship, the complainant was not made party, Lordship.
What you say?
So
Okay,
it
we'll
is
see
very
that.
included, Lordship.
We'll see that.
Yeah.
We'll see that on the next day. You may raise this objection.
Okay.
But before proceeding it, though it seems to be a civil dispute, but there are certain specific allegations are there. So we want to see the case there.
Yes.
Okay.
Complex.
In the meantime, the learned counsel for the parties, learned counsel for the petitioner is also permitted to file an additional affidavit as prayed for. First of all, please this matter again. Huh?
On the 13th, Lordship.
13th, possible to file affidavit?
Okay, lordship, we'll file it.
13th.
Definitely.
Deeply okay.
Like this. This is joint criminal petition for
Difficult. This criminal petition is very difficult. Place this method next week. Yes, Mr. Kartu. हाँ.
Let notice go. Work has been already started.
That is what I am thinking, but this is an apparent illegality.
Maybe
Some laws would be laid down here. But at the same time, work has also been started.
Yeah.
We have just, he has also implemented right now. So we'll have to balance as a read court.
This is the what may be the progress of the what may be state matter.
No, but thing is that ultimately a public project. See, we'll have to make a balance. Ultimately, it's a public project. Award is given in the meantime. It was your mistake. You did not file a synopsis. Therefore, court adjourned this matter sine die.
However,
Otherwise, this would have been a case
Yeah.
of first day, case of stay. Like you have missed the bus. So that's why we made it implemented,
this is
subject to outcome.
well settled position of the law, my lord.
So that we understand, but we cannot help a litigant, sleeping litigant, fancy that we cannot help.
Illegal cannot be legalized.
No, legalized, so if we give an observation, even he will be entitled for compensation if it is an illegality. At least we'll keep this subject to outcome of the requisition. That much, nothing more. It is your fault.
My lord, this is my lord, it can be
20% according to them, 20% completed.
my lord, the tender can be done for the remaining
But
work.
20% who will
Yes.
do this? It's a public exchequer.
That my lord, my lord, the amount definitely he will get, my lord,
No, that no.
for the work already executed by him, my lord.
No, that we understand, but we'll, in the meantime, we'll have to stall the work till we decide in your favor, or we may not decide, we may ask for a retender.
Yes, sir.
So therefore, I thought over it, but I do not think this is a case for stay. Let me dictate this order. Third, M. Kato, first order, so and so, so and so. Second paragraph. Issue notice to the respondents. Full stop, returnable on given date.
30.
At least you give 10-15 days time to serve the notice. We will not give him for whole because we will allow you to dusty.
20, man.
28th of May 2025. Steps explains who appears for respondent number
1 to 4, man.
1 to 4. No formal notice need be issued. However, extra copies within 3 days.
Yes.
Okay.
Yes.
To respondent number 4, registered with AD. In addition, dusty is permitted to file an affidavit in proof of service. Okay. Issue notice on interim. Same will be considered on the next date. We are not keeping, we are keeping still open interim order on the next date. Yes. By the next date fix, the learned counsel for the department shall produce the relevant record. More particularly, the process of record pertaining to the process of tender in connection with the contract of construction of 4 unit of type 2 quarter G+1 at Government Secondary School to Papum.
No, it's
Different.
Sorry for the inconvenience.
Huh?
Sorry for the inconvenience, my lord. Item 13 may be on 27, my lord. Agree.
27. Where is the other part?
Yes.
27.
27.
Okay.
13 to 15, your lord.
13 to 15 on 27.
My
Okay.
my senior's name may be recorded, my lord. So why only?
Today,
On behalf of why only, my
Art Mr.
HZ Rahman.
J. Rahman on behalf of Mr. Waidole, learned ASG, and Mr.
B. Ori.
B. Ori, learned counsel for the respondents. On the joint prayer, the matter stands adjourned and be listed on 27th of May 2025.
My name may also be affected since I mean I
Item number 3 you are for?
for the Applicant, appellant.
appellant J. Zini. Okay. Yes,
Yeah, please, Lordship, here.
at two.
Yes.
How many matters are left? Matters are there, so we'll come back at two. We cannot finish within 10-15 minutes, so therefore, okay, we come. The issue which is there in this case, which has already been dealt by your lordship earlier, which is reported in SEC online, your lordship, for threatening to the witness during the trial, your lordship. So procedure, your lordship has de-alienated, your lordship, which is reported in 2022 SCC online Guwahati 1562 in Neput Rajiyung. Yes, yes, your lordship. So this case will squarely cover this case, your lordship. So now here in this case, the concerned court has directed to register the FIR. This is not permissible, your lordship. That is the case here, that much. So the rest part, they can,
Yes.
they can still proceed.
Yes, your lordship.
They can still proceed.
Apart from that, your lordship, the trial pending before the land, that has also been decided. To get the accused person also.
In a main case,
That judgment
main
is
POXO case.
Ah,
And during the POXO proceeding, your lordship, the victim alleged to have been threatened by this present applicants, your lordship. So on this ground, the learned special court has directed the police to register an FIR under section 195A, your lordship, and 120B.
Now, therefore, it will be regarding the evidence of the witness.
Yes, your
What is
lordship.
the ground of acquittal? See, there are two distinct cases here.
Yes,
One
yes.
is the POXO,
Yes.
other is the threatening a
Yes.
witness.
This is threatening one.
Now, threatening of a witness procedure is different. It is to be on the basis of a complaint, not on the basis of an FIR. This is one aspect of the matter. Second aspect of the matter is, suppose there is an acquittal, but acquittal on what ground?
Yes.
That is very relevant to see.
Yes.
Suppose acquittal is on a different ground, beyond only the evidence of the witnesses.
Yes.
Then we may not proceed further in this case.
Yes.
Where is the judgment?
I have obtained the certified copy.
Why don't you file a bio of an affidavit?
If you wanted to file, but client is in Tawang, Lordship, because of that reason we could not.
See, we cannot go him
Yeah, I
for
wanted to
free,
bring on
but at the
record.
same time, we'll have to see, let us see the.
This is the certified.
But it is better to bring it record by an additional affidavit. He's the accused, isn't it?
Yes, your
Lordship,
lordship.
I am the-
Accused.
Oh,
Now, after registering the affair, what is the ground of acquittal?
oh, Page, Lordship, paragraph 63 onwards, Lordship. Page 59. This is also.
No, these are the evidences. What is the findings of the learned trial? Determination. No appeal against this judgment by
No,
state.
based on that, no appeal.
Mhm.
Based on that, no FL, Your Lordship.
Victim was examined as PW. PW1.
Number one.
How is judgments are and only evidences are recorded? Where is the finding and observations?
Observation.
Petition is in para 66, but it will come from, Your Lordship, para 60, Your Lordship.
Para 60?
60, yes. To find out the
56, okay.
material available in present case, this court consider other corroborative evidence to determine as whether prosecution could prove the guilt of the accused person in present case. In present case, there is allegation that accused so and so has clicked nude photograph of victim and even exhibited sexually explicit video in front of the victim children where nude
failed, and therefore I could not collect the money and I could not deposit the amount. Therefore, I pray for some time to clear at least some amount, because Your Lordship can
No,
say
this is not
you-
some amount. On 25 to 2022, you made a
Yes, I
submission
agree.
that you can pay 2 crore within 8 weeks. Okay. So 8 weeks you were supposed to deposit 2 crores. And you said that you have already paid 1 crore.
No, but yes, during the pendency of the case, we have paid ₹1 crore. Of course, that amount was before 25 to 2025.
That's right. So you were asked to bring on affidavit that 1 crore you have paid.
Yes.
Two aspects. One was that within 8 weeks, beyond that 1 crore, you were supposed to pay 2 crore within 1 week. 8 weeks.
Yes.
Now, other part was that you were asked to file an affidavit showing proof of 1 crore. Where is that affidavit?
That affidavit is could not file, my lord, due to some difficulties. The whole thing is this, my lord. The land that was
No,
mortgaged before
forget
the-
forget about other thing. Let us concentrate today on 25-2. Are you having the order
No,
of 25-2?
No, on that point, I want to say, well, after 25-2, there was a talk of sale of the land, and when the talk was going on,
Please come to the last paragraph. The petitioner shall also file an affidavit to bring on record that the petitioner has already paid 1 crore rupees.
oh, that
What is
affidavit,
this?
of course, that it is a lapse on
We
my
are
part.
not here to look into those scraps of papers. Throw it out. You are directed to file an affidavit. You have not filed it. We will not touch this paper. Then we'll vacate, you go to jail. We'll vacate this and you will go to jail. As simple as that. This is not the way in such a serious matter.
I pray that some time may be allowed so that we can file the affidavit as well as to pay
No,
some
no,
amount.
Mr. Sharma, please see, we have passed an order on a statement of a senior counsel that already 1 crore has been paid. We accepted that yes, it has been paid. But we have directed that please file an affidavit that we have already paid 1 crore and an undertaking that within next 8 weeks we will pay 2 crore. We may give you some relaxation in a given case, whether we'll give or not, that is a different issue. That okay, you have some difficulty, we'll extend the 8 weeks time. But where is your affidavit?
On the day affidavit, I maybe give 2 days time. By 2 days, we will file affidavit.
No, we are fixing it on Thursday. First file the affidavit and give a specific instruction how much amount you will pay. That's all. We will not take it, give back to it. Mr.
Let it be
Counsel, this
after
is
a
not
week.
the way. When there is an order already, this is not the way.
It may be listed after a week, my lord.
You file an affidavit by day after
Okay,
tomorrow, Wednesday, and have an instruction how much this is 2 crore. You have made a commitment.
Yes.
You pay or you face the consequences. The learned counsel for the petitioner submits that inadvertently the affidavit in terms of this court's earlier order dated 25/2/2025 could not be filed. Same would be filed by Wednesday's 7th. List this matter again on 8th, and in the meantime, the learned counsel shall complete their instruction as regards payment of rupees 2 crore as directed in this court's order dated 25/2/2024. Please accordingly.
I'll leave it.
Yes, what is this?
My lord, this is a quashing petition. 482 quashing petition.
Why we should cause this?
My lord, I will come to the point.
Huh?
I'll come to the point.
Where is the-
There is no case against me. FIR is in page number
Case number?
page number 26.
Huh? 20?
26. Page 26. Page 26. It's in written FIR.
Yes, 26. What is your name?
What's it? I'm
Nayum.
Nguyum Taipodia. I'm a petitioner in this case. Also, in this case, I'm a petitioner is a government employee working as a senior nurse officer at Likavali. Also, I'm a married woman and I have a husband and a kid. And my husband was having a illicit relationship with the informant. So what happened during the second week of July 2020?
Let us just understand the affair, then we'll come to the defense.
Yes.
Ms. T. Jenny, learned additional public prosecutor, submits that she may be granted some time to obtain the updated case diary of which police station case number?
Basar police.
Basar police station case number
15/24.
15/24.
Under section 66E of IT Act.
Under section 66E of IT Act
2000.
2000. Okay, 66E we'll see. But
Is it, in this case, nothing is there. I haven't wrongly implicated.
No, I understand, but to come to a conclusion, nothing, we must see may not be 66E. There may be many other.
Exactly, Lord. Exactly.
Yes, we'll see the case there.
Listing this matter.
You are for respondent, informant. Also hard, Swensu for the
Lordship may fix this matter on 15th of this month.
15th.
April.
Yes, Mr. Tara, between whom? Oh, this is bail application.
No, well, this is not bail application.
This is quasi.
Yes.
Item 9.
Item 9. Sorry, I was in the apex court for 1 week.
Huh?
I was in apex court for 1 week, so I could not come.
Where is the affair?
Well,
It is joint application?
No, it is not a joint application. Well, let me explain the matter. The applicant was given a land allotment by the state government on 3/7/2019. And thereafter, land passbook was given to him. Then he constructed the house. Thereafter, there was one gentleman, one Neelam man, he lodged a complaint to the state officer saying that he has illegally trespassed into my land. But factually, it is not correct, my lord. Then he keeps the present respondent number 2, he was the state officer at that point of time. Now, thereafter, what happened, the private complainant, Mr. Neelam and me, have resolved the matter, my lord. So thereafter, my lord, what had happened, against the order passed by the state officer, we filed an appeal under section 12 of the Public Premises Act. And thereafter, my lord, the matter was not being heard. Then we filed the read petition. The read petition, then thereafter it was disposed of on the motion stage. Then direction was given, my lord. Then the deputy commissioner took up the matter. So now the situation is like this, my lord. The present private respondent number 2, who was state officer, is now the appellate authority as well, my lord. 1.
Okay.
Number 2, my lord. Number 2 is that after that, my lord, after that stay order, he has filed a complaint against me saying that I have illegally trespassed it, my lord. So the deputy commissioner,
Where is the affair? Complaint?
charge sheet, my lord.
Charge, complaint or charge sheet affair, where is that?
Charge.
Any material, any case diary of something like that?
Well, charge sheet has been by the only issue which this need
The
to.
issue is this, what I have understood from this line, that admittedly there was an allegation that he encroached land of somebody else.
Yes.
Okay?
Yes.
He was given allotment, there is no dispute on that.
Yes, your lordship.
The respondent, he is a private respondent, the other part,
This-
his respondent number 3.
Two, your
Who is the deputy commissioner?
Yes, your lordship.
Who is the other, who filed the complaint?
No, that was resolved.
No, that was resolved, but somebody filed a complaint that he has encroached my land. Now, his land or private land?
Government land.
Government land.
Yes.
Government land.
Government land.
Government.
Yes, your lordship.
Now, what happened to that proceeding?
That is closed. That is under stay. That is under stay.
That is under stay.
Under stay.
Now, the issue is whether if you have a power under the provision of the Public Premises Act to take certain actions, and it is your admitted case that he has allegedly encroached government land and he can be evicted in terms of the act. Already there is an order of eviction. Appeal is pending.
Then, here.
Appeal is pending, whether on the same set of facts a criminal case will lie. What is the criminal offense registered?
That is Arunachal Pradesh,
PDPP Act, section 3 of PDPP Act.
Arunachal Pradesh, where is that complaint, FIR or something like that?
FIR, page 55.
Page 55. Scan copies are there?
Yes.
Your lordship, it's a charge sheeted case, your lordship.
So scan copies will be
Perhaps
Charge sheet is enclosed.
page 50.
55.
by the deputy commissioner itself.
61.
55 is.
Charge sheet is at page, it starts from page 56 to 61.
FIR is 55.
55.
FIR 55.
Now, in the meantime,
What is the one under 440? Why 447? What is section 3? Please let us see section 3.
Unauthorized, your lordship, destruction of public property, your lordship.
So it is also criminal.
Yes.
Kind
Yes.
of. So
Yes.
two options. One is civil, other is criminal.
Yes.
Correct.
Both are permitted under that.
Yes.
Separate.
Separate, your lordship. No bar.
But, why both the sections will not, why both, all the sections of both the acts will not be applicable in this case is only because of, page number 51 kindly come to this, This is the letter written by the Secretary Land Management to all the Deputy Commissioner and Additional Deputy Commissioner.
This is what is Act Arunachal Pradesh Land Settlement and Records Act.
Correct.
2000.
Here what had happened,
Just a minute, just a minute, just a minute.
Charge sheet PDP Act is dropped, huh? Correct, page 64. The quarrel is premises on 4 meter, my lord.
What is that act?
PDPP.
PDP Act, where is that act?
Volume 1.
3 meter.
Prevention of.
Just give me that. Just once. Public
premises.
No. Can you give me volume 6, either 7, either of the one?
How will you this help you?
Kindly come to charge sheet now, Your Lordship. Kindly come to charge sheet, Your Lordship.
How will you,
Your Lordship,
how is it relevant?
Page 64, Your Lordship. I will show it to Your Lordship. Your Lordship. Page 64. However, from how, Your Lordship, page 64. May I read, Your Lordship? From however only.
64.
Yes, Your Lordship. 64, third line, Your Lordship. However, it has been found that the accused Takot Tagu has encroached upon government land by carrying out construction in more than 34 square meter area. In doing so, he has not maintained the setback area of 4 meter. Now it's coming from the government quarter and rather erected column and beam almost touching it. In the light of the above, a prima facie case of 447 IPC is found well established against the accused Takot Tagu. However, section 3 of PDPP Act could not be established. As such, I am sending up before the learned court to extend his trial for 447.
444 is?
447 is trespass.
For criminal trespass in the old IP.
So now, Your Lordship, Your Lordship, notification here, relevancy is there earlier there was a notification saying that 4 meter setback has to be maintained. But later on, Your Lordship, by this order, it has been, Your Lordship, recalled, Your Lordship. So now,
Now, a thing is that you can take over this land under the Public Premises Act by demolishing this.
yes,
Again, 2003, that Public Premises Act.
So, unauthorized
That's
public
occupant,
premises
yes.
act, you can demolish and
Yes.
take this encroachment, you
Then-
can repossess it.
yes, yes,
Is not it?
yes, Your Lordship.
Now, for same cause, if there is no offense under section 3 of the PDPP Act,
Yes,
so 444, 447 will not be applicable.
yes.
Where is the other matter? That writ petition?
The read is disposed of.
Disposing of in what sense?
In the motion that to take up the appeal pending before the deputy commissioner
And what is the present status?
present is still pending.
Why still pending?
I don't know because
You file a writ petition saying that it should be disposed of.
no, that cannot be because the
Because
present
you say that this is not public land.
no.
Well, then we'll pass it and I think pass a direction that the appeal should be decided within a period of 1 month.
That can be done.
No, again, my difficulty is the same.
There is no
person-
difficulty. See, we can understand. We will not go in favor of a person who has allegedly, I'm using the words allegedly, encroached over government land.
Respectfully not.
Because therefore, there is an appellate provision, let the appeal be decided.
Yes.
The only basic allegation.
So to quash this, we'll have to make an observation.
Yes.
And because your whole argument is that it is intrinsically related between a civil dispute and a criminal dispute.
Yes.
So we'll have to make it clarified.
Yes, Your Lordship.
Melod, just 1 minute indulgence, Melod, I clarify this. Melod, only thing is that I have constructed my house within the allotted 34 square.
Very good.
One. Number two, the allegation is, Melod, that I have not maintained the setback of 4 meters. But, Melod, the page 51,
That's above all, most important thing is that we cannot enter into such factual aspect in a revision petition for quashment.
Yes.
Isn't it? So therefore, what we can decide is that whether any case, prima facie case is made out. If not made out, we'll quash it. But however, since then we'll quash it only on the ground that see there is a civil dispute and a remedy is lying with the state to demolish and retake whatsoever, will not comment on merit.
I
So therefore, this quashment will not be barred, and the court will expect that this matter will be decided at the earliest,
absolutely,
within a period of a month.
Yes.
Yes, my lord,
Give the scan copies.
my lord, I vote out.
Okay, we'll call it from where? Which court?
From the estate officer.
No, That so far relating to this, PS case number, GR case number 664 of 23.
Charge sheet, TCR, perhaps TCR is there. Your Lordship.
Yeah, okay.
My only request, kindly refer in the order, my lord, is page 51. That while hearing the appeal, my lord, the appellate forum under the act shall appreciate page 51.
Will not guide anything to anybody. Moment we guide it, he will pass a judgment, we may go against you. We may even guide it 330. However, at that time, they will ensure that no public premises is encroached by anybody.
Absolutely, I am in agreement with my lord. I even
We want that observation also.
No,
Deputy
no.
Commissioner will strictly ensure that, and if there is an encroachment, it should be demolished.
subject.
So we will not go to that
Well,
level.
subject to follow due process of law.
Of course, due process. What we are saying.
I vote on that. That is the only thing I wanted to know. I'm grateful.
Heard. Mr. Titi Tara, learned counsel for the petitioner. Also has learned additional public prosecutor. The present petition is filed assailing the proceeding of GR case number. Where is that? GR case number?
664.
600
Here, Your Lordship, on top margin, page 16, 664 of 23, Your Lordship. On annex, page 60, 60.
60.
On margin, top margin, your right side.
60.
On top right side. Your Lordship.
60, no?
Yes, Your Lordship. Next are 13. On top right side, my lord. GR number 664 of 23.
GR number 664/2023. The fundamental ground urged by Mr. Tara, learned counsel, is that on the same subject matter of proceeding under the Arunachal Pradesh public premises within bracket unauthorized occupation, something is there thereafter, unauthorized occupation, so and so act, and an appeal is pending. Okay, appeal is pending. And therefore, the FIR in question could not have been registered by the authorities at the behest of the state officer, the respondent number 2. According to Mr. Tara, the subject matter of both the FIR and the proceeding under the aforesaid act, that Arunachal Pradesh Public Premises Act, are same. It is his further contention that even the investing authority has candidly admitted in the search sheet file that no case under section 3 of the PB Act, and therefore in the aforesaid background, a case under section 447 IPC could not have been stated to be made out in the given facts of the present case. On the other hand, the learned additional public prosecutor submits that only for the reason that the civil matter is pending, it cannot be said that in all circumstances a criminal proceeding shall not be maintainable. And therefore, in view of the search sheet file, this court in exercise of its revisional jurisdiction may not entertain the present application and measure at the present.
Inherent power.
Inherent power may not censure such. I have heard the learned counsel for the parties. To appreciate the arguments advanced by the learned counsel for the parties, the facts of the present litigation is required to be recorded, which are as under. Petitioner claims the ownership of the land in terms of an allotment letter issued on 3/7/2019 for an area of land measuring 34 square meter in plot number 45 at ESS sector Itanagar. Full stop. According to petitioner, he had constructed a 3-story building on the basis of such allotment letter. Full stop. Thereafter, one Neelam Lely filed a complaint against the petitioner alleging illegal encroachment of government residential quarter number 18/T-1, East ESS sector Itanagar before the Chief Estate Officer, Government of Arunachal Pradesh, Itanagar. And on the basis of such complaint, a show-cause notice dated 5/8/2022 was issued to the petitioner. Petitioner. The petitioner filed a reply to the show-cause notice and took a stand that the complainant and the petitioner has already amicably settled the dispute. Subsequently, by an order dated, when the decision was taken, by an order dated 18/11/2020, the petitioner was directed to maintain a minimum distance of 4 meters from the government quarter as per the sketch map of allotment order. And it was further directed that any structure falling within the 4 meters distance shall be evicted without any further notice in terms of an executive order dated 3/9/2013 issued by the Secretary, Land Management, Government of Arunachal Pradesh, Itanagar. Being aggrieved by the order dated 18/11/2020 passed by the estate officer, the petitioner has preferred an appeal under section 12 of the Act 2003, that is Arunachal Pradesh Public Premises 2003. According to the petitioner, said appeal is still not being decided. Is that it? Huh? Still not being decided. According to petitioner, though an writ petition was filed, is not it? You filed a writ petition?
Correct. 332. Page 47.
According to the petitioner, though an writ petition was filed, page 47.
Operating portion is the page
47. A writ petition was filed by an writ petition was filed registered as WPC 332/2020 assailing the order dated 18/11/2020 and it was alleged that the appeal was not taken cognizance of. The writ petition was disposed of at the motion stage with a direction to the Deputy Commissioner, KPT Complex, Itanagar, to take note of the take cognizance of the appeal filed by the petitioner on 19/11/2022 against the order dated 18/11/2020, and a date was fixed on 10/12/2020 for adjudication. And it was directed that till 10th of December 2020, the impugned order dated 18/11/2020 passed by the state officer shall remain suspended. It is the contention of Mr. Tara that said appeal has not yet been decided in spite of the order of this court. Rather, the petitioner is now sought to be criminally prosecuted.
Before that, may I assist one point?
Mr. Tara further contests that the order of the settlement order dated 18/11/2021, which is based on the executive order dated 3/12/2012, no more subsist inasmuch as such order was withdrawn by an order order issued by the Secretary within bracket Land Management under number LM-104/2010 dated 3/9/2013. Isn't it? You want to incorporate this? 2013.
Correct.
2013. On the other hand, and accordingly, Mr. Tara contends that the FIR was also lost to the same FIR was lost based on the same facts of the alleged encroachment of a government quarter. Therefore, in the given facts of the present case, according to Mr. Tara, the investigating authority could not have filed a search sheet under section 447 IPC. Per contra, learned counsel for the respondent submits that even if the argument of Mr. Tara is accepted, even if argument of Mr. Tara is accepted, it is clear in the search sheet that the petitioner has constructed beyond the aforesaid 4 meter, in as much as, according to him, the order dated 3, what was that, 3/12, that subsequent order, last I have said, 3/9/2013, 3/9/2013, no way allows construction or encroachment of any public premises. That is,
yes.
public premises. Be that as it may, this court is also of the opinion that the matter is basically within the domain and under the jurisdiction of the authorities under Arunachal Pradesh Swainso Public Premises Act. Though under section 3 of PDPP Act, Swainso years is encroachment of government premises is a criminal offense, punishable offense, punishable offense under the said act. However, in the search sheet, it was clearly stated that no case under section 3 of the aforesaid act is made out, and therefore, in the given facts of the present case, and in present case and findings of the investigating officer as recorded here in above, the prosecution under section 447 IPC would not have been launched against the petitioner. Accordingly, same stance was. However, parting with the record, it is made clear that it is made clear that the present determination shall not be treated as comment on the merit of the appeal pending before the authority. And this court once again shall expect that the appellate authority shall complete the appeal within a specific, within a reasonable time period, inasmuch as there was a direction by this court as recorded here in above in WBC, so and so, so and so. With that observation, the matter stands.
Well, till then, order dated 15/12/2020 passed by Deputy Commissioners.
No, that is relatable to that case. That is
Yes.
already a status quo in earlier order. That is already there. In a criminal case, will not
Yes,
comment.
yes. Oblige, sir.
Mr. Tara, you will not get the order today because you will have to type it, you will have to correct it within a day or two.
Your Lordship, this matter may be kindly passed over for time being. The private respondent counsels engaged in High Court number 1.
What is the issue here?
Issue, in fact, my lord, issue bail application, and the offense is POCSO, under POCSO.
POCSO and compromise. Who is sent to custody of her uncle to pursue her study. Okay, and she think of her mental pressure. She clearly explained under what circumstances he could not disclose to anybody, and her statement that I could gather my courage and disclose it to my brother on such and such date is exactly relatable to her suffering all these years.
My lord, my understanding.
A minor
minor.
of 14 years, not even 14 years, and raped many times under force, under threat.
My lord, 1 second, my lord. My submission, my lord. Yes, my lord. All along, it has been her statement. Either statement before the police under 161, 164, everything, my lord, this has not deviated anywhere.
Not only deviated, there is
No.
nothing to contradict her in your cross-examination that you have stated this in 161, you have stated in 164, nothing.
Why, my lord, why she was prevented from disclosing the alleged.
That the trial court will argue
My
before the trial
My
court.
lord, that
If
is,
you argue before it, I will give you an answer right now. You want that answer?
my lord, let me.
You are arguing. You are arguing at your own risk.
My lord, I'll just take 2 minutes, my lord.
Yes, no, there is no issue taking
My lord.
10 minutes also.
My lord, the prosecution, my lord, why she could not disclose this incident before any relative, my lord? She has been saying that, my lord, because I had a threat that during the course of this rape, the alleged accused has made a video recording. So if she discloses it to anyone, then he will upload the video in the social media. That is what which has prevented the victim from disclosing the incident.
14 years minor.
My lord.
If her uncle says that until and unless you, and she has explained how, in what circumstances she was left alone, at what time you have started this, and how you continue, under what threat. If you argue all this, we'll have to record that counsel has argued so and so, so and so, and then we'll have to answer it.
My lord.
Isn't it? We'll have to answer it in a bail application. Though in the last we'll say that this will not influence the learned trial court. You know how a trial courts are influenced.
My lord, my firm belief is that, my lord, there was no threat, my lord. There is, my lord. Because, my lord,
There is love. Love.
No incident had happened, my lord, as alleged, my lord. In fact, my information, my lord, is that, my lord, she had an appearance with.
There is no cross-examination. There is not even any suggestion that this is a false case, you have not done it.
Now, my lord.
Where is that cross-examination?
Now, my lord.
Please show us.
Since during the course of investigation, my lord, all the mobile phone, computers, etc., all has been seized by the IO, my lord.
That we
Mo-
understand. Please see, you are arguing that this is a false case.
Yes,
Maybe a false case.
yes, because
Okay.
my lord,
No, please listen to me.
my lord.
Your argument will not accept it until and unless you can show from your defense case that you have cross-examined her or suggested her that you have lodged a false case for such and such reason. That this is so and so, so and so. This is called suggestion. Or you could have cross-examined her. Neither you have cross-examined nor you have given any suggestion that this is a false case.
That I have also seen the record, my
Ah.
in fact. Now, my lord, only one line submission is that, my lord.
Yes, not one submission. You submit it.
Since, my lord, IO has seized entire this mobile computer, if at all there was video recording or photograph was taken, my lord, by the accused during the course of the time, then
So you
it is, my
will
lord.
say that
Then it ought to-
there is no material to
Yeah.
say that. But there is a section 29, isn't it? Section 29. They have laid the foundation that she is minor below 17 years. There you have not doubted her age. In none of the evidence, cross-examination you have not done. Now it is established that she is a minor and that allegation is from her evidence and affair that you have raped her. Now honor shifts upon you. Presumption is against you.
Yes, sir. Until, my lord, this investigation
No,
was
forget about
completed, my lord.
investigation. In trial.
Yes,
In trial, a presumption is against you. But of course, the prosecution is to lay the foundation. That foundation they have laid.
my lord.
Now it's up to you. And there is no defense case at all.
My
There is
lord-
no even suggestion that this is a false case.
My lord, just allow me to place one. Of course, this is not
No.
binding to.
No, judgment will come later on. Judgment depends upon each facts. What is the ratio? Is it a ratio?
No, my lord.
Then we rely on judgment only for the ratio, not for others.
My lord,
Yes.
keeping in view the ill health condition of my 1 year and a half boy, my lord, child, my lord.
Think of a
Even my wife is, my lord, ailing, my lord. There is no one to look after them, my lord. It was only me who was earning, my lord, by running this mobile repairing shop, my lord. After my arrest, my lord, there is no one to look after my this wife and this ailing wife and son, my lord. Both of them are sick, my lord. Therefore, my lord, in such situation, my lord, considering the welfare of at least the child, my lord, who is only 1.5 years old, my lord. And more so, my lord, since every evidence, my lord, since trial has already this in the fact end of the trial, my lord, the proceeding, my lord, there is no way, my lord, no chance, no scope, no room for this enforcing any evidence, my lord, any witnesses, my lord, by the accused, my lord. Only the thing is that he is entering defense, my lord. Till such moment, my lord, till such period, my lord.
how can you grant a bail to you when basic allegation is of threat? And that has been revealed
My lord,
that is only the ground.
My lord may kindly put any condition, my lord. But at least, my lord, let the alleged accused take her, his wife and child to some medical hospital, better hospital for treatment, my lord. At least for the sake of these two people who is ailing, my lord, without the alleged accused.
Wait for something, someday 313 is gone, you give the evidence, but one day you bring all the witnesses and judgment will be delivered, you will be acquitted, and then you will take your wife and daughter to treatment.
In case of my lord, the
Dismissed.
conviction, my lord.
Order will follow. Much obliged. Item number? Yes. Yes. What is the impugn order?
Page number 108.
What is the original order? This is the appellate order.
Yes,
What is the original order?
original order against which this order has been passed. That is page number 18.
No. This appeal is filed by appellant Swencho against order dated 26/11/2024.
Yes.
What is the 26/11?
Page number 18.
Page number
18.
18.
Yes. Lordship, that is my memorandum of argument.
Before the court.
Yes. Memorandum of argument.
Argument. Okay.
Yes.
Let us see last page 18. This is an interim order.
Lordship.
Interim order asking you to maintain status quo.
Lordship.
Is that it?
Yes.
Then against who? This was filed by whom?
This order dated 26/11/2024. That was filed by me. Lordship, there was a KEBA order.
No, please tell us. Civil appeal 28/2024 was filed by whom?
Civil appeal 28/24 is
Filed by you.
Filed by me.
You filed by you. There
Yes.
was a status quo order.
Lordship.
Okay. Now, against that status quo order, they have preferred an appeal.
Yes, Lordship.
Is that it?
Yes, Lordship.
That appeal was allowed.
Yes, Lordship. And
What was the final direction in the appeal?
Lordship, I am coming to it. That is page number 108. That is the impugn order. Lordship, they have just filed an appeal without, Lordship, here in this appeal, that is on 11/2/2025. This appeal is filed by the applicant Sri Henley Riva under section 15(2) of Arunachal Pradesh Civil Code Act 2022 against the impugn order dated 26/11/2024 passed by the learned civil judge.
No, please, we'll go to that later on.
Not-
Let us understand the background fact.
Lordship.
First case is that there was a KEBA decision
Lordship.
in favor of you.
No, against.
Against
Yes,
you.
against the petition.
Against you. He prefers an
No.
appeal.
No, sir, I prepared.
Oh, against you. So you prefer an appeal.
Yes, Lordship.
In the appeal, there was an order of status quo.
Lordship.
That interim status quo was challenged by him in the
Lordship.
appeal, and in the appeal order was stayed.
Yes, Lordship.
What is the present status of the appeal pending before the junior division?
Appeal.
Still pending.
Still pending,
Yes.
not proceeded.
Yes, not from, because where our appeal is against the interim order. That status quo was there, so
So
against.
that
the
we
order-
understand, that we understand. Now, what are your grounds of challenge to this order?
Lordship, here in this case,
You take
Lordship,
your seat.
Lordship. The order dated 26/11/2024
issued by the civil judge senior division.
Senior division.
It is not a final order.
This is an interim order.
Yes, it is the interim order.
Mm.
Only status quo has been
Mm.
passed.
Mm.
And the respondent in before this honorable court has ought to prefer and revision under section 115 of CPC.
Why?
Because
If that is an injunction order, now please show us the provision of appeal.
Lordship,
You say that there shall not be any appeal against an interlocutory order. Is it not your ground?
Lordship,
There should not be, even the appeal is not maintainable because there cannot be any appeal against interlocutory order. So
Lordship.
therefore, let us see the provision of appeal.
Lordship. Now, Lordship, may I take this Lordship to page number 20 or 22? This is the appeal filed by the respondent before the learned trial appellate court below.
Under 15.2.
Yes,
So
Lordship.
therefore, that is what I am asking. Let us understand plus 15.2.
Yes, Lordship.
This is 15.2 of Arunachal Pradesh Civil Court Act.
Yes, yes.
Huh.
Appeal, etc. That is 15.2. Appeal from the decree and order passed by a court of civil judge senior division in a original suit and proceeding of a civil nature shall, when such appeal are allowed by law, lie to the court of district judge of the district or the court of additional district judge where such court exists or the high court as the case may be. Your Honor, hearing this as per this provision of section 15 subclause 2, it talks about, Lordship, the original suit. But this is not the original suit. This is an appeal against the KEBA order passed by the village authority.
No, you come to the frontier administration.
No, Lordship, I'm reading Arunachal Pradesh Civil Code Amendment Act 2021, and he has filed the appeal under Arunachal Pradesh Civil Code Act 2021.
But what you filed?
I have before this honorable court, I have
No, the original one. KEBA decision was in whose favor? I have again forgotten.
In my favor,
In your favor. So he preferred an
appeal,
appeal under which provision you have preferred an appeal?
15,
Huh?
under 15 of Arunachal Pradesh Civil Court Act.
How can he prefer under 15 of Arunachal Pradesh Civil Court Act?
And 94 read with order 41, that is appeal against the decree.
Please, where is your appeal?
page number 33,
But please read it. I will not read it. You just tell us.
page number 35.
Appeal under
Appeal under section 96.
section 9
96
of
CPCC.
how can a CPC 96
96 read with order 41 of Code of Civil Procedure.
how cannot be?
Read with section 15 of, may I take
This is section 15 of.
Arunachal Pradesh Civil Code Act 2020.
If we go by your argument
Lordship,
of section 15,
Lordship,
your case is also not maintainable. Number one,
Lordship.
there cannot be any appeal under 96.
But Lordship, as per section 96 of CPC, I can be.
No, not at all. It's a decision of the customary court. See, where your difficulty is, both of your difficulty is that you can proceed not in terms of Arunachal Pradesh Civil Courts Act. You can have your remedy under AFR. As simple as that. If you take back to the history,
Lordship,
then the principle of law was, most particularly the eastern part of this country, that there are customary courts. Okay, whether customary courts will still be recognized, or whether the civil court will take over all the customary laws. So that issue was suo motu taken in Registrar General's case. I think you are aware of that.
Yes.
Registrar General's case. Registrar General's case, the principle laid down in summary was that civil court will have to function and will have to start. Okay. And therefore, this act has came into effect, Arunachal Pradesh Civil Courts Act. Okay, this so far relating to jurisdiction of civil courts. But in Registrar General case, it was also recognized that implementation or starting of general courts will not take away right of the indigenous people of their customary courts. Therefore, a final conclusion was made that in a country where constitution shall prevail, must have a court, civil courts, and that will function. At the same time, you have a right to go for a customary courts. Therefore, for that, customary courts will prevail. In that background, those cases which were taken by deputy commissioners role was kind of a highest authority. Deputy commissioners courts were abolished, and therefore those pending before the deputy commissioners courts, they were given a specific period that please finish it within this period. Isn't it?
Yes, yes.
And at the same time,
Within 6 months.
the appellate authority under the customary courts were also granted to certain civil courts. And therefore, your decision against you taken by a customary court, has you have rightly preferred it before a civil court, but not in terms of either 96 or under Civil Courts Act. It should be under
45.
under the 45.
45 of regulation.
That under the regulation. Okay. Moment you have filed it, he prefers an appeal against that order also is relatable to AFR, not to Civil Courts Act.
Correct.
Though he has written it. So therefore, sum and substance, what will be the issue? Forget about all these technical things. Because everybody is new to this system. We can ignore it, taking that quoting of a section will not affect the right. Ultimately, decision was of a KEBA. You have a right to prefer an appeal. You have rightly opted the appeal, but you have mentioned wrong provisions. Now question is, he will have also a right to prefer against that order to a court, may not be under 15, but in some other ways. At the end, sum and substance of the issue before you is, forget about all technicalities. Now appeal is pending. Who is in the possession of the land as on date?
I am in the position.
Just a minute. Don't be excited. You are in possession. According to you, who is in possession?
So you are in my part, I am in position of this.
So you are in part, you are in position.
Yes.
According to him, he is in your position.
Yes.
So best thing is to maintain both parties' possession, status of the possession, go to the original court, senior division, get the appeal decided.
Yes, Lord.
This is the best option that can be passed. Otherwise, if we go, we'll have to say many things. We have to say, if we go by your technicalities, we'll have to say that your case was not maintainable under section 96. Moment we say that, your appeal is gone. And if we say here that his appeal is not maintainable, then also we will have to say why not maintainable. If we say the reason, that will applicable to you also. So let us not go to all complexities. Anything to be argued here?
No. Your Honor, kindly come to page number 32.
What is that?
This is the LPC land.
No, we cannot go to the merit.
That is regarding.
Not on the merit, because there is a status quo order and
No, status quo order was there already.
Yes.
Status quo has been stayed. See, basically, status quo's intention is to protect the land during the pendency of a dispute. There is a dispute between you and him. There is a KEBA decision in your favor. Now, junior division says, okay, status quo. That staying that entire thing. So, in fact, we can remind you back to the trial court. We can ask the trial court again to rehear the prayer of injunction in presence of both the parties and pass the reasoned order. And will allow you to correct the technicalities in your application so that future is not, do not create complexities.
Yes, my lord. Only the one difficulties is that I have been doing agricultural
Do
activities.
in your part. He says he is in possession in his part.
Okay, this may be recorded that in my LPC.
Status quo so far will say status quo, not a general status quo. Will say status quo in respect of the possession of the respective parties shall be maintained. Okay?
Yes.
And will remand this matter back to the trial court saying that you, because in earlier case, status quo was passed against you without hearing you. This is one of the
Without
grounds.
hearing them.
Huh?
They were there. They filed a caveat petition. The submission of.
But none appears on caveat.
No, they appeared. Not they were.
But what it says that
Yes,
no
they
notice.
appeared.
Okay. No notice was issued.
No.
Okay, anyway, fine.
They were very much there.
So that was an ad interim injunction. You file an objection to the
Yes.
interim injunction. It is hard, afresh, and the appeal be decided. Think over it.
Not same.
If you go further, then we'll have to observe, make many objections, and we understand the difficulties. Because a lawyer practicing in customary court, coming to the civil court, two acts, one is AFR, one is this civil court. Civil court is not at all applicable to it.
Not say, in my humble understanding, the order passed by the customary court, it is a decree in the eye of law. As per Arunachal
You can
Pradesh-
argue it. We will pass this order.
As per Arunachal Pradesh Civil Courts Act.
No, not at all.
Not say,
If we go by Register General, not at all.
not say as per.
That decree, you are relying on a definition of a decree.
Not say,
Decree is relatable to a civil dispute under general courts.
not say.
You will have to distinguish between two things. An order, a decree passed by an authority under civil courts and an order under customary court. Two are absolutely distinct things that has been recognized in Register Generals and said that you have two options. Either you can go for customary or you can go for civil courts. Even a tribal people and a fight between two tribals can instead of going to the customary court can file a suit. Is it not? In terms of Register General. So in Register General, if you have gone through the judgment, specifically distinguish the matter. And subsequently, I dealt with a judgment in Nagaland. This kind of issues, who will have the jurisdiction? I forgot the name, which is a reported judgment. There also we have dealt with all this. So decree to will simply, I can give up 5 minutes dictation that this is cannot be treated as a decree because decree shall or must relate to an order passed by a civil court recognized under Civil Courts Act. And customary courts are not a court within the meaning of a civil court. Except there are some provision under AFR giving them a right of appeal before a civil court. That's all.
My lord, I agree to my lord's suggestion that whatever they are in the position,
Because
let them
we
be in
cannot
position,
decide
whatever
the
in my
merit.
position.
At any rate, whether maintainable or not, at any rate, we cannot decide the merit here.
Yes, Lord.
Only we can decide is that injunction. Injunction means status quo. In my considered opinion, during a pendency, both parties, it should be balanced. You are saying you are in possession of your part. He's saying he's in possession of his part, doing agriculture and all. So both of you continue till the matter is decided. That's all.
Position may be maintained.
Position is maintained.
Lord, in the meantime, this impugn order may be not satisfied.
We'll set aside and remand it back.
And not
That's
say,
all.
with regards to order dated 26/11/2024, no one is being aggrieved with this order because this is just an status quo.
That is what I'm saying.
And it has to be.
That status quo will clarify
are
because he is aggrieved by the
I'm
status.
agree by,
He is
because
aggrieved by the status quo. That status quo will clarify. That status quo will mean the status of possession, which is as on today. You are also claiming possession over this land. You are also claiming possession over this land. So let them continue status of over this, and we'll ask the trial court to decide the matter.
my lord,
And not say-
their land, which is the land which is in their position, that may be, the status quo order may not be passed, and whatever land I am in the position, that what status quo may not be passed, because
Let us see order of the KEBA.
it page number
16.
58 is the type copy,
16 is the type.
50,
5858,
but will not dictate this order today.
yes.
58.
No, not the page.
I'm like,
16 also.
16.
Yes, in the period. CRP. 16.
translated copy is at page number 58, because it is written in a local dialogue.
Yes, this is translated copy.
This
16.
is translated, no?
Yes. Minutes of KEBA decision. May I read, Lords?
Yes.
Today on dated 22 October, a KEBA was held under the chairmanship of Sri so-and-so in presence of following three members, so-and-so, so-and-so. On dated 22nd October 2024, a KEBA Porna was given to Sengo Taipadias, son of so-and-so, was asked to attend the KEBA to settle the boundary dispute regarding the land at Chiku, Hunko, Chaturijo of CG village under the chairperson of so-and-so, and in presence of jury member, PRI member, and elder of CG village, the following decision were made. On 14 September 2024, Sri Sengo Taipodia verbally complained Sri Kirkar Taipodia that Sri Henley Riba has encroached his land. Therefore, on 18 September 2024, a spot verification was done by the villagers of CG village. After that, both the parties come to the conclusion that Robok 3 stump was boundary. So the village made a proposal to find Robok 3 stump and proposed the KEBA meeting. Dated 3/10/2024, again KEBA Porna was issued to the same party for the same subject, but Sri Sengo Taipodia submitted a letter to HGBCG to postpone the meeting as he was not at peace.
Well, what is your name?
My
You
name
are
is
Heleni.
Not Singh.
I am Henley.
You are Henley and she is Sengo.
Sengo Taipodia.
You are not present.
Yes, Lordship, because few months back, my son expired. That's why I was in mental trauma. That's why I prayed for postponement of KEBA. But despite my application, they have conducted KEBA ex parte. And as per AFR, Lordship, there is no any provision for passing a ex parte decision. If
ultimately this matter should go to the
trial court.
Trial court.
Yes,
ultimately.
Lordship.
Yes.
Main trial court.
My lord, kindly
For
come to
title
the
dispute.
finding of the KEBA decision, last paragraph at page number 16. The member present
On 3/1/2024, KEBA Porwana was issued, but he said that I am not mentally.
thereafter again it was postponed. Then again Purvama was issued. Then also he was absent, and he has said that he has requested for some another date, but that letter was not received by this HGVs, the jury members. After this order was passed, we came to know order when he filed an appeal before the Civil Senior Division.
Lordship, in fact, the village authority only after non-appearance of the other party can pass ex parte order as per section 44 of AFR. Not,
What it says?
it says that the 3 consecutively after receipt of the notice, if the parties does not appear, then ex parte order can be passed. But here in this case, I have filed an application with a ground that my son has expired. due to-
Even then, there are 2 dates only.
Lots.
Even then, there are 2 dates. One is on 31/10
Yes.
and other is of
Yes. As per law, that is also lots of
22.
illegal. That is also illegal lots. Minimum at least.
Why don't you have an instruction from your both of your client that you will pass a consent? We cannot decide on merit,
Lots.
but we can pass a consent order remand because this matter will ultimately be pending for years.
Yes, no, trial. This is a big
Better for both of you to go. We'll fix a date. He will appear. You have an instruction whether we can remand this matter to the KEBA again as a consent order.
Yes.
This is one. Otherwise, tentatively, what my view I am saying, I will set aside the appellate order and send it back to the
Keba.
not KEBA, send
appeal.
it back to the trial court,
Civil justice.
and we'll say that injunction be decided or matter be decided afresh, that ask to continue. This will not help anybody. This will not help anybody. Ultimately, in my view, if it is goes in your favor, you will come to the appellate court. If it is goes against him, it will go to he will come. Then thereafter, either of the party will come to High Court. Nothing will happen.
My lord, my humble submission, ultimately this matter is going to boil down to the Kevang decision against. We know that it will be
If you know,
Keva de novo trial. It will happen, and we are not shying away from that also. De novo trial.
so
Yes.
let's do it right now.
Yes,
We'll be-
we are only agreed by this status quo because
That's why we'll give you a status quo till today and remand the matter to the KEBA. KEBA
No,
will
no,
take a
this-
decision
this-
giving him a chance.
my lord, this status quo
We
may
are
be
also
removed.
becoming a KEBA now today.
This status quo may be removed because there is I have been doing the agriculture
Status quo
activities.
is not removed.
Yes. Lordship.
See, what I'm saying is, when there is a dispute and prima facie, he has not been given adequate chance. Do you want to observe me all this? That's why, because he will refer to the 45 or what was that? So procedure for
44.
procedure for ex parte.
Procedure for ex parte is there. When the opposite party receives
So
the
taking all these things,
yes,
ultimately everything will be decided.
My lord,
receive notice.
my only request is that I may
Okay.
be allowed to collect the vegetable and other items.
Those are misleading. Your
Those are not
We
misleading.
will not, we are not saying anything. We tried to have a KEBA. We'll pass this order day after tomorrow.
Lordship, one more submission. That is
We'll go on merit.
My lord, kindly
We'll go
pass
on
a
merit.
balance order because
See, we do not know. We'll go on merit. We'll see the provision of 45, when an injunction can be passed, whether whether prima facie we are satisfied that KEBA has violated the decision. Of course, we'll file a
Yes.
status quo. Prima facie case, balance of convenience, irreparable loss and injury. We'll see that.
my lord, we are ready for de novo trial.
So
But
if-
this
if-
only agreed. We are only
We
agreed
are
for this status
giving
quo.
you, if you are
Because before status quo
we'll
order,
give you, if we'll give a status quo order also, if you say that we'll going back to KEBA and KEBA decision are taken very quickly, we'll give fix a time frame. As per you agree, he will appear, he will lead evidence, you will lead evidence, thereafter KEBA will take a call.
my lord, one more submission is they are in position. They are submitting. They are in position of the land, and I am also saying that I am in position.
That's why,
in respect to our position, status quo may not be maintained. But
see, status quo is, therefore, we are saying, see, status quo is given when there are dispute, who is in the possession. Who is in possession? You are claiming you are in possession, he is claiming in possession. So we'll say that status quo be maintained, the KEBA will take a fresh decision. But that order we can pass only if you given consensus. If not, then we'll go on merit. That's all.
Lordship,
List this matter again on day after tomorrow.
Lordship, with regards to facts, I have to make one more submission. Your Honor, I have filed an additional affidavit. That was not in the CRP. Lordship, here in this.
Have you called this?
Yes, I have already, on the last occasion I have filed.
It is here.
Yes. That is clear.
Okay, but see, facts, we cannot comment on facts. Who is owner, where is the boundary, what is the boundary in LPC, what is not, we cannot say anything.
Lordship, what happened?
Of course, if we enter into the merit whether the status quo was granted was right or wrong, this is the limited issue before
Yes.
us. We will have to see what is the boundary and status quo. Even if we grant, we may verify that if he can say prima facie case that this is my LPC, or you can show this is my LPC in terms of this is my boundary, or in terms of this is my ownership, this is my boundary. So we may say status quo be maintained in respect of this.
Lordship, on that day also, 11/2/2025, as soon as status quo order was vacated, he has again encroached upon my land. Now also, your Lordship, if the status quo order is lifted, he will again encroach upon my.
My lord, this is totally, absolutely false and lies before this honorable court. Because they are the one
See,
after.
the difficulty is this, you are not understanding. We are in a civil dispute. We cannot take witnesses here. We cannot bring witnesses here. Who is correct, who is not.
Yes,
We will have to go by the material on record. I tried to convince you both where to go, where not to. On Wednesday, we'll pass this order on merit, ignoring the technicalities.
Lordship,
Place this matter again on Wednesday.
additional affidavit.
much more.
We'll see all we'll see
Additional affidavit after getting the status, after suspending the order, then this opposite part of the petitioner.
If
they-
both of you will end nowhere. I know that. If you don't properly advise your clients, both of you will end nowhere.
Yes.
And at the end of the day, both of you, the purpose of this customer reports is to have a mutual decision. Now, almost sorry to say, this has gone.
Status quo,
Now-
regarding status quo, my lord, I may be only allowed to collect the vegetables and other items.
We'll pass this order on the merit. We'll see your document. We'll see his document, and we'll take the principle of prima facie case, balance of convenience, irreparable loss of injury, and pass an order. Ultimately that will decide what is what. Day after tomorrow. Okay, that's all. Please flag mark those your ownership documents on the basis of which you claim your land. Anything is there. If not necessary, then the materials on the basis of which you want to say that this is my position. And you also show us those things on the basis of, forget about the KEBA decision, original things.
LPC.
And Lordship,
I have
LPC is
annexed.
also subject to challenge.
No, we know that.
That has been fraudulently obtained.
No,
Maybe.
DC has already given the
See,
clarification saying this duty
Forget
of.
about that. A deed is fraudulent or not is a subject matter of trial.
Trial, Lordship.
In an injunction, if prima facie I am satisfied that there is a sale deed, if I am prima facie satisfied that so and so is possessing, this is on the prima facie. We can say that possession in respect of so and so be maintained in his favor. He might have a fraudulent LPC. You might have a LPC which is actually genuine. So if there are two LPCs, we'll say that both the boundaries and land be maintained by either of the parties on the basis of the LPC.
My lord, I may be allowed to put one more document if my lord permit me.
Lordship, he has not even filed a reply. Now he is claiming to submit.
Otherwise also because
So
he-
we will go by his
because my
we-
lord,
we will go by his appeal.
because my lord, he
Here we cannot take new documents.
Lordship.
We will have to see what is his case before the KEBA.
Lordship.
On what basis KEBA has passed this order?
No basis, Lordship.
Okay. Second thing is that court has passed an injunction order on what basis?
Lordship.
Then secondly, such injunction was stays on what basis? If these are followed by proper principle of law, will not interfere, will dismiss your petition.
Lordship.
And if we see that no, you have a case,
Lordship.
we'll restore the order passed by the trial court and send it back.
Lordship. Lordship, but the.
But best option was to give a consensus, maintain status quo, go back to the KEBA. After 10 years, we will again go back to the KEBA. Take my word.
That would have been the best for both.
Take my word. After 10, 15 years, after 3, 4 round of cases, again it will either go back to Keba or somebody is to file a civil suit.
Much.